Before we begin, a quick and important disclaimer. The following content is focused on the historical and legal evolution of retirement assets during the 1980s and is provided strictly for educational and entertainment purposes. It does not constitute legal, financial, or tax advice. Laws regarding marital property and qualified retirement plans are complex and vary significantly by jurisdiction and individual circumstances. You should conduct your own due diligence and consult with a qualified attorney or financial professional before making any decisions regarding your personal finances or legal matters. Imagine it is 1984. You have spent 15 years climbing the corporate ladder, diligently contributing to a brand new type of savings vehicle called a 401k. You believe this money is yours, a private contract between you and your employer. But then, a process server knocks on your door with divorce papers. Suddenly, the legal landscape shifts beneath your feet. You are about to find out that your retirement security is no longer an individual asset, but a marital one, subject to being carved up by a judge in a way that didn't even exist 3 years prior. In the 1980s, the American Divorce Court became the front line of a financial revolution, where billions of dollars in future wealth were redistributed overnight. If you think your modern retirement account is safe, you need to understand the decade where the rules were written, because the precedents set in those wood-paneled courtrooms are exactly what dictate your net worth today. Today, we are conducting a deep dive masterclass into the 401k divorce explosion of the 1980s. We are going to deconstruct how the introduction of the 401k in 1978 collided with the Retirement Equity Act of 1984 to create a perfect storm of litigation. For the modern viewer, this isn't just a history lesson. This is about understanding the DNA of American property law. By the end of this series, you will understand how marital property is defined, how the Qualified Domestic Relations Order, or QDRO, changed the math of separation forever, and why the 1980s transition from traditional pensions to 401ks made divorce one of the most significant financial events in a person's life. To understand the chaos of the 80s, we first have to look at what came before. In the 1970s, retirement was largely a black box. Most workers relied on defined benefit pensions. You worked for 30 years, you got a gold watch, and you received a monthly check until you passed away. In a divorce, these were nightmares to value. How do you split a monthly check that hasn't started yet? Judges often ignored them entirely, leaving the non-working spouse, usually the wife, with zero claim to the husband's future security. This created a massive social crisis as divorce rates climbed, leading to what sociologists called the feminization of poverty. Then came Section 401k of the Internal Revenue Code. When it was implemented in the early 80s, it shifted the responsibility of saving from the company to the individual. Suddenly, instead of a vague promise of a future check, workers had an actual account balance. They could see the money, felt like a bank account, and because it felt like a bank account, divorce attorneys started eyeing it like a shark eyes a life raft. The 1980s represented a cultural shift where the me generation met the reality of our money. In 1981, the first 401k plans began to proliferate across corporate America. This was the era of the yuppie, the rise of Wall Street, and a massive bull market. As these accounts grew, they became the largest single asset in many households, often surpassing the equity in the family home. In a 1983 case study, a mid-level manager at a firm like General Electric might have seen their 401k grow from $0 to $50,000 in just a few years. When that manager headed for divorce, the legal system had no clear manual on how to handle it. Was this a gift? Was it separate property? Or was it a joint investment in the marriage? The tension reached a breaking point, leading to the Retirement Equity Act of 1984, or REA. This is arguably the most important piece of legislation in the history of American divorce, yet most people have never heard of it. Before REA, pension plans were governed by ERISA, the Employee Retirement Income Security Act of 1974. ERISA had an anti-alienation clause, which basically meant the money in a retirement plan could not be assigned to anyone else. It's untouchable. Creditors couldn't get it, and for a long time, ex-spouses couldn't get it either. Imagine the legal battles of 1982. An ex-wife might be awarded half of the retirement assets by a state judge, but when she took that court order to the husband's employer, the company would say, "We can't pay you. Federal law prohibits us from giving this money to anyone but the employee." This created a jurisdictional limbo, where thousands of women were awarded money on paper that they could never actually collect. The Retirement Equity Act of 1984 solved this by creating the QDRO, the Qualified Domestic Relations Order. This was the legal skeleton key. It allowed a state court to override federal anti-alienation rules. For the first time, a plan administrator was legally required to recognize the right of an alternate payee, the ex-spouse, to receive a portion of the participant's benefits. This change didn't just happen in a vacuum. It was fueled by the economic data of the time. Throughout the 80s, the U.S. divorce rate hovered near its historic peak. Simultaneously, the transition from stay-at-home roles to dual-income households was in full swing. However, there was still a massive disparity in who held the retirement accounts. In 1985, historical trends showed that men held the vast majority of 401k assets. Without the REA and the QDRO, the 1980s would have seen a generation of women enter their senior years with literally no financial safety net despite decades of contribution to a domestic partnership. Let's look at a hypothetical case study from 1987 to illustrate the complexity. Consider a couple, John and Mary. John worked for a tech firm in California, a community property state. He started his 401k in 1982. By 1987, the account was worth $100,000. Under the new laws, the court had to determine how much of that $100,000 was marital property. If John had $10,000 in the account before they got married, that might be separate property. But the growth on that $10,000 during the marriage? That was a gray area. Did the market gains belong to John or the couple? Lawyers in the 80s had to become amateur mathematicians. They had to track every contribution, every employer match, and every cent of interest earned over a 5-year period. This gave rise to the covered fraction method. This is a formula where you take the number of months the person was in the plan during the marriage and divide it by the total number of months they were in the plan. $text, marital portion equals \frac, \text, months of participation during marriage, \text, total months of participation, $. This formula became the standard for deciding who got what. If John was in the plan for 60 months and was married for 48 of those months, 80% of the account was considered marital property. Mary would then be entitled to 50% of that 80%. This type of granular calculation was revolutionary. It turned the 401k from a retirement fund into a negotiation chip. But the 1980s weren't just about the math, they were about the psychological warfare of the era. This was the decade of Wall Street and fatal attraction. Money was a scorecard. When the 401k became divisible, it changed the way people approached divorce. Spouses began hiding assets, taking out 401k loans to deplete the balance before filing, or shifting investments into high-risk assets hoping to tank the value during a lean year. The 1980s also introduced the concept of the tax trap. In the early days of 401k divorces, if a judge ordered $20,000 to be paid out to an ex-spouse, no one was quite sure who was responsible for the taxes. If the husband withdrew the money to pay the wife, he would be hit with a 10% early withdrawal penalty and income tax. He might lose 40% of the value just trying to comply with the court. The QDRO fixed this by allowing the money to be rolled over into the ex-spouse's own IRA, deferring the taxes. This was a massive win for financial stability, but it required a level of paperwork and precision that many 1980s law firms were unprepared for. As we move forward in this deep dive, we are going to look at the specific 1980s court cases that define valuation dates. The exact moment the 401k stops being joint and starts being separate. We will explore the Black Monday crash of 1987 and how it wiped out marital settlements overnight, leaving couples fighting over money that no longer existed. This era was the Wild West of retirement law, and the lessons learned then are the only reason you have any clarity in your financial life today. To understand why the 1980s became such a pressure cooker for 401k litigation, you have to look at the sheer speed of the transition from traditional pensions to these new individual accounts. Imagine a couple named David and Susan living in a suburb of Chicago in 1986. David has been an engineer for a decade. For the first 5 years of their marriage, his future was tied to a traditional pension plan that promised a fixed monthly benefit. Then, his company shifted to a 401k. Suddenly, David wasn't just a worker. He was an unwitting portfolio manager. In a single year, David's account balance might swing by 20%. When Susan filed for divorce, the court was forced to decide which version of David's wealth was real. Was it the balance on the day she filed, or the balance on the day the judge signed the decree? In the volatile 1980s market, that 3-month gap could represent a difference of $30,000. This leads us to one of the most contentious legal battlegrounds of the decade: the valuation date. In today's world of 2026, we have instant digital records and automated valuation software, but in 1987, everything was done on paper, usually quarterly. If a couple was divorcing in October, they might be looking at a statement from June. This delay created a massive loophole for financial maneuvering. Case studies from this era show that savvy spouses would often attempt to time their filings based on market fluctuations. If the market was dipping, the employee spouse wanted the valuation done immediately to lower the buyout price. If the market was soaring, the non-employee spouse wanted to wait as long as possible to capture that growth. This legal tug-of-war turned the 401k into a weapon. Consider the step-by-step process of a 1980s 401k audit during a high-stakes divorce. First, the forensic accountant had to obtain the summary plan description, a document that was often 50 pages of dense legalese. They had to determine if the plan allowed for in-service withdrawals or loans. Why? Because in the mid-80s, a common tactic was for a spouse to take out a maximum loan against their 401k, up to $50,000, and use that cash to pay for legal fees or hide it in non-traceable assets. Since the loan reduced the net balance of the account, it appeared on the surface that there was less marital property to split. The courts eventually caught on, but not before thousands of spouses were left with half of a depleted account, while the other spouse walked away with the cash. Then came October 19, 1987. Black Monday. The Dow Jones Industrial Average plummeted over 22% in a single day. For the thousands of American couples in the middle of a divorce that week, the financial impact was catastrophic. Imagine a settlement had been reached on October 15th, where David agreed to pay Susan a flat sum of $100,000 from his 401k, which was worth $200,000 at the time. By Tuesday morning, David's entire account was worth only $156,000. If the court order specified a fixed dollar amount rather than a percentage, David was suddenly losing nearly two-thirds of his remaining net worth instead of half. This single day of market carnage forced a complete rewrite of how QDROs were drafted. Lawyers stopped using fixed dollar amounts and started using percentages, usually including a clause that accounted for market gains or losses until the date of actual distribution. The 1980s also saw the rise of the specialized pension appraiser. Before the 401k, you didn't need a math genius to divide a house and a car. But by 1988, the complexity of 401k vesting schedules required expert testimony. Step 1 for these experts was determining what was vested versus non-vested. If David had $100,000 in his account, but $60,000 of that was employer matching funds that wouldn't belong to him for another 2 years, was that $60,000 marital property? The historical trends of the time show a split in the courts. Some states like California and New York argued that the right to earn that money was acquired during the marriage, so it was a marital asset. Other states argued it was a mere expectancy, a maybe, and therefore couldn't be divided. This meant that depending on which side of a state line you lived on, your divorce settlement could look radically different. Another layer of this masterclass involves the tax implications that were often ignored until it was too late. In the mid-80s, the IRS was still figuring out how to handle these new split accounts. There was a period of intense confusion regarding the 10% early withdrawal penalty. If a judge ordered a 401k to be liquidated to pay a settlement, who paid the penalty? If the employee spouse withdrew the funds, they were hit with the tax bill. If the non-employee spouse received the funds, they often found themselves with 40% less than they expected after federal and state withholdings. This led to the development of the gross-up calculation. This was a step-by-step mathematical adjustment where the court would increase the total award to the non-employee spouse to ensure that after taxes were paid, they ended up with the intended net amount. It was a messy, imprecise system that led to years of appeals. Beyond the math, we have to look at the discovery phase of an 80s divorce. This was the era before centralized databases. If a spouse wanted to hide a 401k, they often could. An engineer might have an old 401k from a previous employer that they simply didn't disclose. Private investigators in the 1980s spent a significant amount of time digging through trash and intercepting mail to find 401k statements from companies like IBM, AT&T, or Xerox. These found assets often changed the entire trajectory of a case, moving a settlement from a few $1,000s to hundreds of thousands. The 1980s was the decade where the American family stopped being a social unit and started being viewed by the law as a small business. The 401k was the primary ledger of that business. As we move into the next phase of this deep dive, we have to look at the most controversial aspect of all: the marital coverture fraction. This was the formula used to separate what you earned while single from what you earned while married. Sounds simple, but as we will see, it was anything but. How do you account for the fact that the $5,000 David put in while single grew into $50,000 because of the contributions made while he was married to Susan? Does the growth follow the principal, or does it follow the marriage? We are just scratching the surface of how these rules were forged in the fires of 1980s litigation. In the next part, we are going to look at the specific plan rules. Every company had a different 401k structure, and some of them were designed specifically to be divorce-proof. We will explore how major U.S. corporations fought against the QDRO system to protect their executives' assets, and the landmark Supreme Court cases that eventually forced them to comply. If you think a company's internal policy can protect your retirement from a legal judgment, you need to see what happened when the titans of industry went up against the family court system. We are diving into the secrets of the Fortune 500 401k wars next. In the mid-1980s, a quiet but fierce war broke out between the HR departments of the Fortune 500 and the American family court system. Companies like IBM, Ford, and General Electric had spent millions of dollars setting up their 401k infrastructures, and they viewed these plans as private contracts between the employer and the employee. When the first wave of Qualified Domestic Relations Orders, or QDROs, started hitting their mailrooms, the corporate reaction was often one of total defiance. These companies didn't just see a court order. They saw a threat to the fiduciary integrity of their retirement trusts. They argued that if they started cutting checks to ex-spouses based on a state judge's whim, they would be in violation of federal ERISA laws, potentially disqualifying the entire plan's tax-exempt status. Imagine you are a high-level executive at a major oil company in Houston in 1985. We will call him Robert. Robert has been with the company for 20 years and has amassed a 401k balance that reflects his climb through the ranks. When Robert and his wife, Linda, decide to divorce, the court orders that 40% of Robert's account be transferred to an account in Linda's name. But when Linda's attorney sends that order to the oil company, the corporate legal team sends it back with a formal rejection letter. They claim the order is not qualified because it doesn't follow the specific technical language hidden deep within the company's 1,000-page plan document. This was a common tactic in the 1980s. Corporations acted as gatekeepers, using bureaucratic red tape to stall the distribution of funds for months or even years. This corporate resistance created a massive bottleneck in the U.S. legal system. Step 1 of these Fortune 500 401k wars usually involved the plan administrator. In the 1980s, the plan administrator held immense power. They were the ones who decided if a QDRO was valid. If they said no, the burden of proof shifted back to the spouse. This led to a historical trend where divorce attorneys had to specialize specifically in ERISA law, just to get past the corporate front desk. We saw cases where a spouse would spend $10,000 in legal fees just to get a company to acknowledge that a 401k balance existed. A primary example of this friction involved the concept of immediate distribution. Most 401k plans in the 80s were designed for one purpose: retirement. The rules often stated that money could only be touched if the employee reached age 59 and a half, died, or left the company. When a divorce court ordered an immediate payout to an ex-spouse, companies fought back, arguing that the plan didn't allow for early withdrawals for anyone, even under a court order. This created a scenario where Linda might be awarded 40% of the account in 1985, but the company would tell her she couldn't actually see a dime of it until Robert retired in the year 2005. This forced the legal system to evolve. Lawyers started drafting what became known as separate interest orders. This was a step-by-step legal maneuver where the ex-spouse portion of the 401k was literally carved out into a separate sub-account within the same plan. This allowed the ex-spouse to manage their own investment choices within the company's 401k menu, even though they were no longer married to the employee and had never worked for the company. Imagine the administrative nightmare for a company like Chrysler, suddenly managing thousands of accounts for people who were never on their payroll. The cost of this administration was so high that many companies began charging QDRO processing fees, some reaching as high as $1,000 per order, which was a significant sum in 1988. The stakes were raised even higher when we look at the issue of survivor benefits. In the 1980s, if a 401k participant died before the divorce was finalized or before the QDRO was processed, the money often stayed with the company or defaulted back to the estate. There were tragic case studies where a spouse who had been married for 30 years was left with nothing, because their ex-husband died 48 hours before the judge signed the paperwork. To combat this, 1980s attorneys began using a legal tool called a joinder. This was a process where the 401k plan itself was joined as a party to the divorce lawsuit. By doing this, the court could issue an injunction preventing the company from moving or paying out any funds until the divorce was settled. This was the nuclear option. It effectively froze the employee's account, preventing them from even changing their investment allocations while the legal battle raged. As these battles moved through the courts, a new conflict emerged: the valuation of company stock. In the 1980s, many 401k plans were heavily weighted toward the employer's own stock. If you worked for a company like Coca-Cola or IBM, your 401k wasn't just a basket of mutual funds, it was a pile of corporate shares. This created a massive valuation headache. If the stock price was high during the marriage but crashed during the divorce proceedings, who bore the loss? In one landmark 1989 case study, an executive's 401k was valued at $500,000 on the day of separation, but by the time the company approved the QDRO, the stock had dropped by 30%. The court had to decide if the ex-spouse was entitled to a percentage of the shares, or a specific dollar amount based on the historical high. This leads us to the concept of the valuation date versus the distribution date. In the 1980s, these two dates were rarely the same. The valuation date is when you decide what the pot of money is worth. The distribution date is when the check actually clears. In the high inflation, high volatility environment of the late 80s, the gap between these two dates could destroy a settlement. Professional scriptwriters and legal experts of the time documented cases where the delay caused by corporate plan administrators resulted in the total collapse of the marital settlement agreement, forcing couples back to the beginning of a multi-year litigation process. But the most secretive part of these Fortune 500 401k wars involved the top hat plans. These were non-qualified deferred compensation plans for the highest-earning executives. Unlike a standard 401k, these plans were not protected by the same ERISA rules. They were essentially unsecured promises from the company to pay the executive later. In the 1980s, these became the ultimate hiding place for marital assets. Because they didn't show up on a standard 401k statement, many spouses never even knew they existed. Forensic accountants had to look at tax returns and proxy statements to find these shadow accounts. When they did, the legal fights became even more vicious, as these plans often lacked any mechanism for being split or assigned to a non-employee. The 1980s proved that the 401k was not just a savings account. It was a legal entity with its own set of rules, defenses, and vulnerabilities. The battles between spouses were really just the tip of the iceberg. The real conflict was between the state's power to divide property and the corporation's power to control its own assets. By the end of the decade, the court system had largely won, but at the cost of thousands of families being dragged through a process that was expensive, slow, and psychologically draining. As we move into the next part of this deep dive, we are going to look at the darker side of this history, the rise of 401k fraud. We will examine the step-by-step methods used by spouses to drain accounts before a spouse could file for divorce, the role of offshore entities in the late 80s, and the shocking reason why some 401k accounts were completely untouchable even by the most powerful judges in America. If you think a QDRO is a silver bullet, you need to see what happened when the money simply vanished before the lawyer could even pick up a pen. We are looking at the era of the phantom 401k next. By the late 1980s, the financial stakes of the 401k had become so high that a new darker phenomenon emerged in the American legal landscape: the phantom account. This was the era of the disappearing digital dollar. Before the 2026 level of transparency and real-time oversight we see today, a 401k was essentially a series of magnetic tapes and paper ledgers managed by a distant corporate entity. This distance created a massive opportunity for what forensic accountants now call pre-divorce asset depletion. Imagine a husband named Michael, a high-earning sales director for a pharmaceutical company in New Jersey in 1988. Michael knows his marriage is failing 6 months before he actually files for divorce. He realizes that his 401k balance is his ticket to a comfortable second act, but the new QDRO laws mean half of it belongs to his wife, Sarah. In the 1980s, Michael didn't need a complex offshore account to hide this money. He just needed to exploit the internal rules of the 401k itself. Step 1 in Michael's plan was the strategic loan. In 1988, many 401k plans allow participants to take out loans for general purposes, often up to 50% of the vested balance or $50,000, whichever was less. Michael takes the full $50,000 out. On paper, His 401k balance drops from $150,000 to $100,000. He takes that $50,000 in cash and places it into a safe deposit box or a non-interest-bearing account in another state. When the divorce proceedings begin, Sarah's attorney looks at the 401k statement and sees a $100,000 asset. They split it 50-50, giving Sarah $50,000. Michael walks away with $50,000 from the settlement plus the $50,000 he has hidden in cash. This was a rampant historical trend that left thousands of spouses undercompensated because the legal system had not yet developed the forensic tools to track the flow of loan proceeds. This era also saw the rise of the fabricated hardship withdrawal. Under 1980s IRS guidelines, a participant could withdraw funds from their 401k if they could prove an immediate and heavy financial need. Michael might collude with a friendly contractor to produce a fake invoice for emergency home repairs that never happened, or claim a medical emergency for a distant relative. Once the money was out of the 401k, it lost its status as a protected retirement asset and became fungible cash that could be spent, gifted, or moved before the court could issue a restraining order. By the time Sarah's lawyer requested a discovery of assets, Michael could truthfully claim the money was gone, spent on life's emergencies. But the most sophisticated version of the phantom 401k involved the strategic change of investment. Imagine if Michael, seeing the market volatility of 1987 and 1988, intentionally moved his entire 401k allocation from a safe money market fund into a highly aggressive, speculative tech fund right as the market began to soften. If the account value plummeted by 30% during the divorce, he could claim it was simply a bad investment move. However, after the divorce was finalized and the assets were divided based on the lower value, he would move the money back into a stable fund, having successfully reduced the amount he had to pay his ex-spouse while retaining the long-term recovery potential for himself. The forensic accountants of the 1980s had to develop a step-by-step methodology to catch these phantoms. The first step was the look-back period. Courts began demanding 5 years of 401k statements rather than just the most recent one. They were looking for sudden drops in value or large loan activities that coincided with the breakdown of the marriage. The second step was the tracing of the loan. If a loan was taken out, the employee had to account for every dollar of that money. If they couldn't prove it was spent on a legitimate marital expense, the court would often add that amount back into the marital pot, a process known as recapturing. This meant Michael would be treated as if the account still had $150,000, even if the cash was missing. However, even with these forensic advances, there was one area where the money could truly vanish: the small business 401k. In the 1980s, many entrepreneurs set up their own 401k plans where they were both the employee and the plan administrator. This was the ultimate lack of oversight. A business owner could literally write themselves a check from the 401k trust, label it as an administrative expense, and vanish the balance. Because there was no massive HR department at a company like IBM to act as a check and balance, the spouse was often left fighting a ghost. Case studies from 1989 show that in small business divorces, the 401k was often the most manipulated asset of all, frequently requiring a full audit of the company's books just to verify if the retirement plan even existed. Then there was the issue of the involuntary phantom account. This happened when a company went bankrupt in the late 80s. With the leveraged buyout craze of the era, many companies were saddled with massive debt and collapsed. If a couple was in the middle of a divorce and the husband's company went under, the 401k assets were generally protected by ERISA, but the administrative process of getting that money out of a bankrupt entity could take years. The asset became a phantom because it was technically there, but it was legally inaccessible. This led to settlements where one spouse would take the house and the other would take the rights to a frozen 401k. 10 years later, that 401k might be worth 3 times the house, or it might be worth nothing. It was a high-stakes gamble that defined the financial uncertainty of the decade. To add another layer of complexity, we have to look at the role of the 1980s pension consultant. These were individuals hired to put a price tag on future benefits. In the case of a 401k, they had to project what a balance in 1988 would be worth in 2018 to determine if a spouse should be paid a lump sum today or a percentage later. This involved complex actuarial math and assumptions about inflation and interest rates that were often wildly inaccurate. Imagine a court in 1985 assuming that inflation would stay at 10% forever. They would overvalue the 401k, leading to a settlement that was unfairly weighted against the employee spouse. These mathematical errors created a different kind of phantom wealth, money that appeared to exist on a ledger, but would never be realized in the real world. The 1980s taught the American legal system that you cannot simply trust a balance sheet. You have to look at the history of the account, the intent of the transactions, and the reliability of the plan itself. This decade of fraud and manipulation is the reason why modern 401k providers have such strict reporting requirements and why today's QDROs are so much more difficult to evade. But for those living through it, the 401k was a house of mirrors. As we move into the next part of this masterclass, we are going to look at the most explosive part of the 1980s divorce, the battle over the employer match. Many people don't realize that in the 80s, employer contributions often didn't vest for 10 years. We will look at the step-by-step legal battles over money that was earned during the marriage, but didn't officially exist until after the divorce. Who owns the future money? We are diving into the vesting wars and the secret formulas used to divide wealth that hasn't even been paid out yet. This is where the real millions were won and lost. The concept of vesting in the 1980s was the ultimate financial cliffhanger. To understand the vesting wars, you have to realize that in 1985, the corporate world operated on much longer timelines than we do in 2026. Today, we often see immediate vesting or perhaps a 3-year cliff. But in the mid-80s, it was common for a company to require 10 years of service before a single cent of the employer's matching contribution actually belonged to the employee. This created a massive legal gray area in divorce courts. If a husband had been working for a firm for 8 years, and the marriage was ending, he had a 401k balance that looked impressive on paper, but half of it was technically a mirage until he hit that 10-year mark. Imagine a woman named Barbara and her husband, Stephen, living in Ohio in 1986. Stephen is a senior analyst at a major manufacturing firm. His 401k statement shows a total balance of $80,000. However, $40,000 of that is Stephen's own contributions, and the other $40,000 is the company match. According to the plan rules, Stephen is only 60% vested because he has only been with the firm for 6 years. If they divorce today, the company technically only recognizes $64,000 as his property. Barbara's lawyer argues that the full $80,000 is a marital asset because the work was performed during the marriage. Stephen's lawyer argues that the unvested $16,000 doesn't exist yet, and might never exist if Stephen is laid off or leaves the company tomorrow. This led to the creation of the reserved jurisdiction method. This was a step-by-step legal strategy where the court refused to divide the 401k immediately. Instead, the judge would issue an order saying, "We will wait." They would essentially keep the divorce case open for years. The court would decree that if and when those funds vested, Barbara would be entitled to her share based on a specific formula. This kept ex-spouses tethered to each other long after the emotional bond was broken. Barbara would find herself calling Stephen's HR department 3 years after the divorce just to see if he still had a job, because her entire retirement security depended on his continued employment at that specific firm. Historical trends during this decade show that this uncertainty created a massive incentive for the employee spouse to quit. We have seen case studies where an individual would intentionally leave a high-paying job just months before a major vesting cliff simply to spite an ex-spouse and ensure they received nothing from that portion of the 401k. To counter this, courts began implementing the concept of the hypothetical value. If the court determined that a spouse acted in bad faith by leaving a job to avoid sharing a 401k, they could charge that spouse for the value of the lost assets, essentially forcing them to pay out of their share of the house or other tangible property. The math of these vesting wars required a deep dive into the 1980s coverture fraction, specifically the difference between the service fraction and the contribution fraction. A service fraction looks at the total time employed versus the time married. But in a 401k, which is a defined contribution plan, that math is often unfair. If Stephen contributed heavily in the last 2 years of the marriage, the service fraction would undervalue Barbara's contribution to the household during that high-earning period. Attorneys began fighting over the discrete tracing method. This involved a line-by-line audit of every paycheck and every market fluctuation from the date of the wedding to the date of the separation. Step 1 of the discrete tracing method was identifying the source of every dollar. In the 80s, this was a manual nightmare. A forensic accountant would have to sit with a stack of paper statements and a calculator. They would have to subtract the premarital balance, then account for the growth on that premarital balance using a pro rata interest rate, then isolate the marital contributions and their specific growth. If the market went up 12% in 1984 and down 4% in 1987, those numbers had to be applied specifically to the balances as they existed in those moments. This was where the real millions were won and lost. A slight error in the interest rate calculation over a 7-year marriage could swing the final settlement by tens of thousands of dollars. Then there was the issue of the 401k as a replacement for the pension. In the late 80s, many companies were terminating their old-fashioned pension plans and rolling the value into 401ks. This was a process called a plan conversion. For a couple in a divorce, this was a mathematical nuclear bomb. The pension was a promise of future monthly income, while the 401k was a bucket of cash. How do you compare the two? Lawyers would hire actuaries to perform a present value calculation. They would ask, how much cash would we need today to buy an annuity that pays the same as that old pension? If the conversion happened during the divorce, the 401k balance might suddenly double or triple overnight. This led to frantic legal filings to freeze assets before a conversion could take place, as the tax implications of moving pension money into a 401k were different for a single person versus a married couple. Imagine the high-stakes negotiations in a law office in 1989. You have a 401k that is partially vested, a pending plan conversion, and a volatile stock market. The lawyers would often engage in what was called the trade-off. Since the 401k was so hard to value and divide, the husband might say, you keep the house and the station wagon, and I keep the entire 401k. In 1989, that might have seemed like a fair deal. But the historical data tells a different story. The house might appreciate at 3% a year, while the 401k, riding the massive bull market of the 90s, would go on to grow by 15% a year. By the time 2026 rolls around, the spouse who kept the 401k is a multimillionaire, while the spouse who kept the house is struggling to pay property taxes. This disparity is why modern courts are much more hesitant to allow one spouse to buy out the other's interest in a retirement account. The 1980s also saw the introduction of the non-qualified 401k, often called a wrap plan or a mirror plan. These were for the highest earners, the CEOs and VPs who hit the IRS contribution limits early in the year. These plans had zero vesting protection from the government. They were entirely at the mercy of the company's solvency. In a divorce, these were treated like a game of hot potato. No one wanted to take the mirror plan as part of their settlement because if the company went under, the money vanished. But if the company thrived, the mirror plan was where the real wealth was hidden. The step-by-step discovery of these plans required looking for specific line items on a W-2 form that didn't match the standard 401k contributions. As we conclude this segment on the vesting and conversion wars, it becomes clear that the 1980s was the decade that killed the simple divorce. The 401k made every separation a complex corporate audit. But there was one final hurdle that many couples never saw coming until they tried to spend their money. It wasn't the lawyers, the judges, or the ex-spouses who got the last laugh. It was the Internal Revenue Service. In the next part of our masterclass, we are diving into the 1980s tax traps. We will look at the exact moment a divorce settlement becomes a tax nightmare, the secret IRS rulings that wiped out entire 401k balances, and why the phrase tax-free transfer was often a lie in 1988. If you think the QDRO protected you from the taxman, wait until you see the loophole the IRS used to double-dip on American divorces. We are uncovering the 401k tax scandals next. The Internal Revenue Service in the 1980s was navigating uncharted waters just as much as the family courts were. When the 401k was first gaining traction, the tax code was a labyrinth that even seasoned accountants struggled to map. The core problem was a fundamental question of identity. Who is the owner of the tax liability when a 401k is split? In the early 1980s, before the technical corrections of the Tax Reform Act of 1986, the IRS often defaulted to the participant. This meant that if a husband was ordered to pay his ex-wife $50,000 from his 401k, the IRS initially viewed this as the husband taking a distribution and then making a gift to his ex-wife. The result was a tax disaster. The husband would owe income tax on the $50,000, plus a 10% early withdrawal penalty if he was under age 59 and a half, while the wife received the cash net of nothing. Imagine a high-stakes scenario in 1985, involving a couple we will call James and Patricia. James is a vice president at a logistics firm in Georgia. As part of their divorce settlement, James agrees to give Patricia $100,000 from his 401k to settle her claims on the family home. They draft the agreement in a local coffee shop, and the judge signs off on it. James calls his plan administrator and requests the withdrawal. 2 months later, James receives a check for $100,000, which he promptly signs over to Patricia. He thinks the deal is done. However, when April 15th rolls around the following year, James receives a 1099-R for the full amount. Because he was 45 years old at the time, the IRS hits him with a $10,000 penalty plus $40,000 in federal and state income taxes. James has effectively paid Patricia $100,000 while it cost him $150,000 of his actual net worth. Patricia, meanwhile, has no tax liability on the cash she received. This historical trend of the accidental tax trap led to some of the most bitter post-divorce litigation of the decade. It wasn't until the 1984 Retirement Equity Act was fully digested and further refined by the Tax Reform Act of 1986 that the IRS officially recognized the alternate payee, the ex-spouse, as the one responsible for the taxes, but only if a very specific set of steps were followed. This gave birth to the 1980s QDRO tax protocol. Step 1 of this protocol required the order to specifically state that the distribution was being made pursuant to Section 414P of the Internal Revenue Code. If those numbers weren't in the document, the IRS could ignore the QDRO status. Step 2 involved the election of a direct rollover. In the late 80s, if the ex-spouse took the 401k money as a cash payment, the plan was required to withhold 20% for federal taxes immediately. For someone like Patricia, who might have needed that full $100,000 to buy a new house, suddenly seeing only $80,000 arrive in her mailbox was a shock. To avoid this, her lawyer had to set up a qualified individual retirement account, or IRA, before the money was even moved. This allowed the funds to jump from James's 401k to Patricia's IRA without the IRS ever touching a penny. However, the 1980s were also the era of the tax-free loan scam. Some spouses tried to get clever. They would take a loan from their 401k, give the loan proceeds to their spouse as a settlement, and then stop paying back the loan. They figured that since it was a loan, it wasn't a taxable distribution. But the IRS was ahead of them. The moment a 401k loan went into default, it was treated as a deemed distribution. The employee spouse would get hit with the taxes and penalties anyway, often years after the divorce was finalized, leading to a secondary wave of bankruptcies in the late 80s as the IRS began auditing these creative settlements. We also have to examine the 1980s step-up in basis trap. When a couple divides a house, they usually deal with capital gains. But 401ks are entirely composed of pre-tax dollars. In 1987, many divorce attorneys who were used to traditional property division didn't account for the fact that $1 in a savings account is worth more than $1 in a 401k. If James had $100,000 in a standard savings account and $100,000 in a 401k, giving Patricia the savings account while he kept the 401k was not an equal split. James's $100,000 was actually only worth $60,000 after future taxes. This led to the development of the tax-adjusted valuation method. Accountants would have to project James's future tax bracket 20 years into the future to determine the current value of the 401k. If they got it wrong, and in the 80s with tax rates shifting from 70% down to 28% under Reagan, the entire math of the divorce could be fundamentally flawed. Another layer of this deep dive involves the mid-80s controversy over the QDRO and the 401k matching stock. Many companies, especially in the industrial sector, matched 401k contributions with company shares. If those shares were transferred to an ex-spouse via QDRO, it triggered a complex rule known as net unrealized appreciation, or NUA. In the 1980s, if Patricia received James's company stock, she could potentially pay capital gains rates on the growth rather than higher income tax rates, but only if the stock was moved into a brokerage account rather than an IRA. Most 1980s lawyers didn't know this. They would default to the IRA rollover, accidentally costing their clients thousands of dollars in unnecessary taxes. Case studies from 1988 show that the difference between an IRA rollover and an NUA distribution could be the difference between a comfortable retirement and a marginal one. Then there was the 1980s problem of the double dip. This happened when a spouse was awarded a portion of the 401k as property, but then later tried to claim the income from that same 401k as a basis for alimony. The courts were divided. If Patricia was already given half of the 401k at the time of the divorce, could she later ask for more alimony because James was living off the other half? This created a scenario where James felt his 401k was being taxed twice, once by the court in the property split, and once by the court in the alimony calculation. This led to the landmark 1980s legal theory that pension and 401k assets, once divided, should be excluded from future income calculations. The complexity of these tax laws created a new class of professional, the QDRO consultant. By 1989, you couldn't just rely on a divorce lawyer. You needed a specialist who understood the intersection of family law, ERISA, and the ever-shifting IRS tax code. These specialists would charge thousands of dollars just to review a 3-page order. They were looking for the ticking time bombs that the IRS had hidden in the fine print. The 1980s proved that in a 401k divorce, the government is always the third party in the room. They don't care about the emotional trauma or the fairness of the split. They only care about the timing and the characterization of the funds. As we've seen, a single missing paragraph or a poorly timed withdrawal could turn a fair settlement into a financial ruin. But taxes were only part of the problem. What happened when the 401k wasn't just cash or stock, but was tied up in the very company that was about to be liquidated in a hostile takeover? In the next part of our masterclass, we are looking at the 1980s corporate raiders. We will explore how the era of Gordon Gekko and junk bonds decimated 401k balances in the middle of divorce proceedings. We are going to see what happens when the 401k you are fighting for suddenly becomes the target of a leveraged buyout. The world of corporate espionage meets the divorce court next. The 1980s was defined by the era of the corporate raider. This was a period where industrial titans were being stalked by aggressive investors using high-yield junk bonds to finance hostile takeovers. While the world watched the headlines of multimillion-dollar buyouts, a secondary crisis was unfolding in the living rooms of America. When a company was targeted for a leveraged buyout or LBO, its employee benefits were often the first things on the chopping block. For couples in the middle of a divorce, a 401k tied to a company under siege was like trying to value a house while it was being moved during an earthquake. Imagine a husband named Thomas who worked for a major textile conglomerate in North Carolina in 1988. Thomas had spent 15 years with the firm, and his 401k was almost entirely comprised of company stock. His wife Diane was seeking 50% of that account in their divorce. Just as their lawyers were finalizing the QDRO, a corporate raider announced a hostile bid for Thomas's company. Suddenly, the stock price doubled in a week due to the takeover speculation. Diane's lawyer immediately froze the proceedings, demanding a higher settlement based on the new valuation. But then the raider succeeded, took the company private, and loaded it with billions of dollars in debt. To pay off that debt, the new owners liquidated the 401k plan's employer stock and replaced it with high-risk junk bonds issued by the parent company itself. Within 6 months, the company's credit rating was slashed, and the value of that 401k plummeted far below its original pre-takeover price. This was the brutal reality of the 1980s LBO craze. For divorcees, the 401k was no longer a stable retirement bucket. It was a pawn in a larger game of corporate espionage and financial engineering. Step 1 for any divorce attorney in this environment was the monitoring of the 13D filings. A 13D is a form required by the SEC when an entity acquires more than 5% of a company's stock. In 1988, if a husband's employer saw a 13D filing, his divorce lawyer had to act within hours to lock in a valuation date. If they waited, they were at the mercy of the raider. Historical trends show that this era gave rise to the contingent settlement. This was a complex legal maneuver where a spouse would be awarded a percentage of the 401k, but the order would include a recapture clause. This clause stated that if the company was sold or the 401k was liquidated within a certain time frame after the divorce, the ex-spouse would receive a secondary payment to reflect the windfall profit. This was essentially a way for Diane to bet on the corporate raider's success without being penalized by the immediate market volatility. However, these clauses were notoriously difficult to enforce. If the company went private, the transparency of the 401k's value vanished, leaving the ex-spouse with no way to verify if they were being cheated. Then there was the issue of the overfunded pension grab. In the mid-80s, many companies realized their traditional pension plans had more money than they needed to pay out future benefits. To unlock this cash, corporations would terminate the pension plan, pay out the minimum required to employees, often rolling it into a 401k, and keep the surplus for corporate expansion or to fend off raiders. For a divorcing couple, this was a nightmare. The spouse who expected a lifelong pension suddenly found themselves with a lump sum 401k transfer that was worth significantly less in the long run. The math of the 1980s didn't account for the loss of the guaranteed survivor annuity that a pension provided. Case studies from 1989 suggest that these corporate maneuvers cost American divorcees billions in potential long-term wealth, as they were forced to trade a secure future for a volatile, debt-laden 401k account. To navigate this, forensic accountants developed the step-by-step corporate stability audit. They didn't just look at the 401k balance. They looked at the company's debt-to-equity ratio and its vulnerability to a takeover. If a husband worked for a fat and happy corporation with little debt and a high cash reserve, his 401k was a prime target for a raider, and therefore a high-risk asset in a divorce. The lawyers would often advise the non-employee spouse to take their share in cash or other assets, rather than staying tied to the company's 401k. This was the era of the cash-out strategy. Imagine if Diane had insisted on her 50% share of the 401k in 1988, only to see the company declare bankruptcy in 1990 due to the debt from the LBO. Because she was now an alternate payee under a QDRO, she was a creditor of the plan. But in the 1980s, the priority of QDRO holders in a corporate bankruptcy was still a legal gray area. Some judges ruled that the ex-spouse should be paid before other creditors, while others argued they were just another face in the crowd. This uncertainty led to a historical trend of settlement front-loading, where spouses would take less money overall if they could get it in a liquid form immediately, rather than waiting for a 401k distribution that might never come. The corporate raider era also introduced the concept of the golden parachute 401k. For top executives, a takeover meant a massive payout. These payouts were often structured as accelerated vesting of 401k matches and deferred compensation. If an executive was divorcing during a takeover, their 401k might grow by 500% in a single afternoon. This created a frantic race to the courthouse. If the husband could finalize the divorce the day before the takeover was announced, he could potentially keep the entire windfall as separate, post-marital property. If the wife could delay the final decree by just 24 hours, she could claim it was a marital asset. We saw cases in 1987 where lawyers were literally sprinting to the clerk's office to file papers before the opening bell of the New York Stock Exchange. But the 1980s weren't just about the giants. The leveraged buyout culture trickled down to small businesses too. A local medical practice or a small law firm might be sold to a larger conglomerate. In these cases, the 401k plans were often merged or terminated. The step-by-step tracking of these assets required a level of diligence that was rare in 1989. Many spouses simply lost track of their 401k portions as plans were moved from one financial institution to another during these corporate mergers. This created a generation of lost 401ks that people are still trying to find in 2026. This period of the 1980s proved that the 401k was not an island. It was tethered to the health, greed, and survival of the American corporation. As we move into the next part of this deep dive, we are going to look at the psychological toll of this financial warfare. We will explore the rise of the 401k hostage, a situation where one spouse uses the complexity of the retirement plan to refuse a divorce for years. We will look at the step-by-step breakdown of the 1980s mediation system, and why the 401k became the #1 reason why friendly divorces turned into decade-long bloodbaths. We are looking at the era of the legal stalemate next. The legal stalemate of the late 1980s was not just about the money, it was about the weaponization of time. In the high-stakes environment of American family law, the 401k became the ultimate anchor, used to drag out proceedings until the opposing side simply ran out of resources or will to fight. This gave rise to a phenomenon known as the 401k hostage. Because the rules surrounding the Qualified Domestic Relations Order were so new and the corporate response was so slow, a spouse who controlled the account could effectively freeze the entire family's financial future by refusing to cooperate with the valuation or the plan administrator. Imagine a couple named Mark and Jennifer living in New York in 1989. Mark is a mid-level executive at a telecommunications giant. He has a 401k balance of $200,000. Jennifer wants a divorce, but Mark does not. Mark realizes that as long as the 401k is in dispute, the judge is unlikely to finalize the property distribution or the divorce decree. Mark begins a step-by-step campaign of administrative obstruction. First, he claims he has lost his plan documents. Then, when the court orders him to produce them, he provides outdated summaries from 1982 that don't reflect the current 401k structure. When Jennifer's lawyer finally gets the correct documents from the company, Mark challenges the valuation of the mutual funds within the account, demanding a forensic audit of the fund's underlying assets, an impossible task that takes months of legal back and forth. This was the era of the legal stalemate, where the 401k acted as a barrier to freedom. Historical trends from 1988 and 1989 show that the average time to finalize a divorce involving a high-value 401k increased by nearly 40% compared to the pre-401k era. The complexity of the asset provided a legitimate-sounding excuse for delay. Attorneys would spend dozens of hours in depositions arguing over the difference between a market-to-market valuation and a book value valuation. In the world of 2026, we can solve these disputes with a few clicks. But in the 1980s, every disagreement required a formal motion, a hearing, and a court reporter. The psychological toll was immense. For someone like Jennifer, the 401k was a ghost. She knew it was there, she knew she was entitled to half of it, but she couldn't touch it, move it, or borrow against it. Meanwhile, Mark continued to manage the account, potentially making investment choices that favored his long-term goals over hers. This led to a historical trend of settlement by exhaustion. Jennifer might eventually agree to take only 20% of the 401k just to get the divorce over with so she could move on with her life. This tactical use of the 401k essentially allowed the account holder to buy their way out of a fair settlement by leveraging the other spouse's need for closure. The 1980s mediation system, which was designed to keep couples out of court, often collapsed when faced with a 401k. Mediators were trained in communication and compromise, but they weren't ERISA experts. A typical step-by-step mediation session in 1987 might start with the house and the kids, which went well, only to hit a brick wall when the 401k came up. The mediator would ask for a balance, and the husband would provide a number. The wife's lawyer would then point out that the number didn't include the unvested match, or the dividend reinvestments. The mediation would stall, the parties would become defensive, and the case would be kicked back into the adversarial court system. We have to look at the role of the 1980s court-appointed referee. In many jurisdictions, judges became so overwhelmed by 401k disputes that they began appointing independent attorneys or accountants to act as referees. These referees were tasked with one job: determine the marital portion of the retirement account. But even these experts struggled. Imagine if Mark had a 401k from a previous job that he rolled into his current company's 401k. The referee would have to trace the growth of those separate funds through multiple market cycles and plan changes. If the records from the first company were destroyed or lost during a merger, the referee had to make a best guess estimate. These estimates were often challenged in court, leading to even more delays and creating a cycle of litigation that could last 5 or 6 years. Case studies from this era also highlight the emergence of the 401k loan as a stalemate tactic. Mark might take out a maximum loan against the 401k to pay for his high-priced divorce attorney. This effectively used Jennifer's own future money to fund the legal battle against her. Since the loan was a debt of the account, it lowered the net value available for distribution. Courts in the late 80s were forced to develop the concept of the marital waste claim. Jennifer's lawyer would argue that by depleting the 401k to pay for a lawyer, Mark was committing financial misconduct. The court would then have to hold a separate mini-trial just to decide if the 401k loan was a legitimate expense or a tactic to reduce the settlement. The stalemate often extended to the QDRO drafting process itself. Even after a judge gave an oral ruling on how to split the 401k, the parties still had to agree on the written language of the order. Mark's lawyer would draft a version that was intentionally vague, knowing the plan administrator would reject it. Jennifer's lawyer would draft a version that was too specific, potentially overstepping the plan's rules. The two sides would bicker over the phrasing of a single paragraph for months. This led to a situation where a couple was legally divorced, but remained financially joined because the QDRO hadn't been approved. In the eyes of the IRS, they were single, but in the eyes of the 401k provider, they were still a ticking time bomb of liability. This era of the stalemate changed the way Americans viewed marriage. It was no longer just a social contract. It was a high-stakes financial partnership that was increasingly difficult to dissolve. The 401k was the ultimate tether. By 1989, the backlog of cases involving disputed retirement assets was so severe that some states began implementing mandatory arbitration specifically for 401ks. They realized that the standard legal process was simply not equipped to handle the intersection of federal labor law and state family law. As we analyze the fallout of these 1980s bloodbaths, we see the roots of our modern system. The pain and frustration of the stalemate era led to the standardized QDRO forms we use today and the requirement for immediate asset disclosure. But for those caught in the web in the late 80s, the 401k was a prison. It was a decade where the pursuit of a fair share often cost more in legal fees than the asset was worth in the first place. But the stalemate was only half the story. While the lawyers were fighting in the courtrooms, the technology of the 1980s was creating a whole new set of problems. In the next part of our masterclass, we are diving into the 1980s paperwork nightmare. We will explore the lost ledgers, the microfiche disasters, And what happened when a company simply forgot that a 401k existed? We are going to look at the step-by-step process of reconstructing a retirement account from nothing but a handful of old pay stubs. If you think your records are safe in a digital cloud, you need to see what happened when the 1980s paper trail went cold. We are looking at the era of the vanished record next. The era of the vanished record in the late 1980s was a byproduct of a society caught between two worlds. Corporate America was attempting to modernize, moving from physical file cabinets to early mainframe computers, but the transition was messy, fragmented, and prone to catastrophic data loss. In 2026, we are accustomed to seeing our portfolio balances updated every second on a smartphone. In 1989, a 401k balance was often just a line item on a dot matrix printout that arrived in the mail 4 times a year. If those papers were lost, and the company's magnetic backup tapes were corrupted or overwritten, that wealth effectively ceased to exist in the eyes of the law. Imagine a woman named Cynthia and her husband Robert, who are finalizing a divorce in 1989 in Seattle. Robert worked for a regional airline that was swallowed up by a national carrier in 1985. During the merger, the HR departments were consolidated, and thousands of employee files were moved across the country in literal cardboard boxes. When Cynthia's attorney subpoenaed Robert's 401k records to determine the marital portion of the account, the new parent company sent back a stunning response. We have no record of a 401k for this employee prior to 1986. This created a legal void. Cynthia knew Robert had been contributing since 1981, but the evidence had vanished. This was not an isolated incident. Historical trends show that the merger and acquisition fever of the 1980s resulted in the loss of retirement data for hundreds of thousands of workers. For Cynthia, this meant her legal team had to begin the grueling step-by-step process of forensic reconstruction. Step 1 of forensic reconstruction involved the hunt for the secondary paper trail. Since the company records were gone, the burden shifted to the individual. Cynthia had to dig through boxes in the garage, looking for old pay stubs. In the 1980s, pay stubs were often printed on carbon copy blue paper that faded over time. A forensic accountant would use a magnifying glass to find the specific deduction code for the 401k. If the code was 41k or RET, they could prove that money was being withheld. But proving a deduction is not the same as proving a balance. The accountant then had to estimate what that money would have grown to by cross-referencing historical market data with the plan's investment options from that specific year. Step 2 was the microfiche deep dive. Many companies in the late 80s backed up their archives on microfiche, miniaturized photographic film. If a law firm was wealthy enough, they would hire a specialist to spend days in a dark room at a corporate warehouse, scrolling through thousands of images of ledger sheets to find a single name. Imagine the cost of this in $1989. Often, the legal fees to find the record exceeded the value of the account itself, leading to a new type of settlement injustice where the spouse with less money was forced to waive their right to the 401k because they couldn't afford to prove it existed. This era also faced the problem of the orphan 401k. This happened when a small company went out of business and the plan administrator simply disappeared. In the 1980s, there was no centralized federal database to track abandoned 401k plans. If Robert's old employer shuttered its doors in 1984, the money might be sitting in an escrow account at a bank that had also been merged or liquidated. Case studies from this period describe spouses who spent years acting as amateur detectives, calling defunct banks and searching through the Federal Register to find the trail of a missing 5-figure retirement account. The 1980s paperwork nightmare extended to the actual drafting of the QDRO. Because there were no standardized templates, every lawyer was essentially inventing the wheel. A single typo in a social security number or a plan name meant the order was rejected by the plan administrator. But because communication was handled via the U.S. Postal Service, it would take 3 weeks to receive the rejection letter. Then the lawyer would fix the typo and mail it back. Another 3 weeks. If this happened 4 or 5 times, a year would pass without the account being split. During that year, the market could crash, the participant could take out a loan, or the company could go bankrupt. The technology gap also created the snapshot fallacy. In 1988, if a judge ordered a 401k split as of December 31st, the plan administrator might not be able to provide a valuation for that specific day. They could only provide the value as of the last quarterly statement, which might be September 30th. In a volatile market, that 90-day discrepancy was a legal minefield. We saw cases where the market rose 10% in the final quarter of the year, and the spouses fought for months over who was entitled to that 3-month bonus growth. The 1980s courts were forced to issue orders based on incomplete data, creating a generation of settlements that were, at best, educated guesses. Another layer of this nightmare was the role of the 1980s plan custodian. These were the banks and insurance companies that held the actual cash. They often had different records than the employer's HR department. In a high-conflict divorce, a lawyer might receive two different statements for the same 401k on the same day. One from the employer saying the balance was $50,000, and one from the custodian saying it was $48,000. The $2,000 difference could trigger a whole new round of depositions, expert testimony, and legal bills. The culprit was usually float, the time it took for the money to travel from the payroll department to the investment fund. But in the suspicious atmosphere of a divorce, it was often viewed as a sign of fraud. The 1980s paperwork crisis eventually forced the government to act. This decade led to the passage of stricter record-keeping requirements under the Department of Labor, but those rules came too late for many 1980s divorcees. They were the pioneers of the 401k age, and they paid the price for the system's early incompetence. For Cynthia and Robert, the lack of records eventually led to a stalemate. With no way to prove the pre-1986 balance, the judge simply split the 1986 to 1989 portion and left the rest as a lost asset. Robert kept the hidden growth, and Cynthia walked away with a fraction of what she helped build. As we reach the conclusion of this masterclass, we have to look at the legacy of the 1980s 401k divorce. The scars left by this decade changed the way every American thinks about marriage, work, and retirement. But there is one final shocking reality that many of these 1980s divorcees are only discovering now, decades later. It involves the delayed QDRO and the massive wealth transfers that are happening today because of mistakes made 40 years ago. In our final part, we are going to look at the 2026 fallout of the 1980s mistakes. We will explore what happens when an old QDRO from 1988 was never actually filed, the multi-million-dollar lawsuits currently hitting 401k plan administrators, and the step-by-step guide to checking if your own family history has a ticking 401k time bomb attached to it. The 1980s aren't over. They are just getting started in the courts of today. We are concluding with the 401k ghost stories of the present next. The 1980s may feel like ancient history, but in the world of ERISA law and retirement planning, that decade is a living, breathing entity that continues to shape the balance sheets of 2026. We are currently witnessing a phenomenon that legal scholars call the ghost QDRO. These are court orders that were drafted, signed, and tucked away in dusty legal folders in 1987 or 1988, but were never actually submitted to the 401k plan administrator. Back then, there was no digital tracking, and many attorneys mistakenly believed that a judge's signature was the final step. They didn't realize that without a formal qualification letter from the employer, the 401k remains legally undisturbed in the name of the original participant. Imagine a woman named Linda who divorced her husband, Richard, in 1985. The court awarded her 50% of Richard's 401k, which at the time was worth a modest $30,000. Linda moved on with her life, assuming that the money was set aside. Richard also moved on, eventually retiring in 2020. Because the QDRO was never formally processed by his employer's HR department, Richard spent 40 years watching that $30,000 grow into $1 million nest egg, fueled by the explosive market cycles of the 1990s and the 2010s. Now, in 2026, Linda discovers the oversight. She files a motion to enforce the 1985 order. The legal question that keeps modern judges awake at night is this: is Linda entitled to the $15,000 she was owed in 1985, or is she entitled to 50% of the $1 million Richard has today? This is the billion-dollar glitch. Historical trends show that thousands of these unexploded financial bombs are currently sitting in the basements of county courthouses. When these cases hit the courts in 2026, the potential outcomes vary wildly by state. Some courts apply the doctrine of laches, essentially telling Linda she waited too long to claim her prize. But other courts, citing the federal protections of ERISA, argue that the money was hers the moment the judge signed the decree, and she is entitled to all the market growth that occurred over the last 4 decades. This results in Richard, now in his 70s, suddenly losing half of his retirement savings to a woman he hasn't spoken to since the Reagan administration. Step 1 in understanding these modern ghost stories is the audit of the plan administrator. In the 1980s, plan administrators were often just a single person in a corporate office. Today, they are massive financial institutions managing trillions of dollars. When a 40-year-old QDRO is suddenly presented to a company like Fidelity or Vanguard, It triggers a high-level internal review. These institutions have to determine if the 1980s order meets the hyper-technical standards of modern law. If the order mentions a plan that was merged 3 times and eventually dissolved, the administrative nightmare of tracing those assets back to 1985 can cost tens of thousands of dollars in forensic accounting fees. Case studies from 2024 and 2025 show a surge in malpractice lawsuits against the estates of 1980s divorce attorneys. Families are discovering that their parents' wealth was decimated because a lawyer failed to file a single piece of paper 40 years ago. This is why, for the modern viewer, the lesson of the 1980s is one of extreme diligence. The step-by-step verification process today involves contacting every former employer from that era and requesting a participant statement to see if any alternate payees are listed on the account. If you are the child of a 1980s divorce, you might find that your inheritance is tied to a QDRO that was never finished. Another modern fallout is the problem of the double-paid benefit. In the chaos of the late 80s, some plan administrators actually paid out the full 401k to the husband, forgetting they had a QDRO on file for the wife. Decades later, the wife comes looking for her share. The company has already paid the money out once. Does the company have to pay it again out of their own pockets? In several landmark cases, the answer was yes. This has led to a massive tightening of corporate security around 401k distributions, but it doesn't change the fact that many 1980s accounts were essentially paid out to the wrong people due to the paperwork nightmares we discussed in earlier parts of this masterclass. Consider the psychological impact on the next generation. We are seeing cases in 2026 where the children of 1980s divorces are acting as the primary investigators. They are digging through microfiche and calling defunct HR departments to secure their mother's or father's rightful share of a 401k that has been compounding for 40 years. It has turned the 401k from a retirement tool into a multi-generational legal claim. The sheer amount of wealth currently trapped in these 1980s legal loopholes is estimated by some experts to be in the tens of billions of dollars. The historical data from the 1980s also reminds us of the fragility of our current systems. If a massive cyber event or a total collapse of digital records were to occur today, we would be right back in the 1989 paperwork nightmare. The 1980s taught us that wealth is only as real as the records that support it. For the people who fought those 401k wars, the lesson was expensive and often heartbreaking. They were the test subjects for a financial experiment that we now take for granted. As we wrap up this masterclass, look at the 401k not as a simple bank account, but as a complex legal contract forged in a decade of corporate raiding, tax volatility, and legal stalemates. The 1980s didn't just give us the 401k. It gave us the rules of engagement for how we divide our lives and our futures. Whether you are currently going through a separation, planning for retirement, or helping an aging parent navigate their finances, you are operating within the framework built by the lawyers and legislators of 40 years ago. The deep dive into the 1980s 401k divorce explosion reveals a fundamental truth about American wealth. It is never truly settled until the final document is filed, verified, and stamped by the institution holding the cash. The ghosts of 1985 are still out there, and they are moving through the fiber optic cables of our modern financial world, waiting to be found. Understanding this history is the only way to ensure your own financial security isn't derailed by a mistake made before the internet even existed. The story of the 1980s 401k is a story of transition, from the collective security of the pension to the individual responsibility of the investment account. It was a decade that forced us to quantify the value of a marriage down to the last penny and the last day of a vesting schedule. While the hairstyles and the technology have changed, the fundamental battle over who owns the future remains exactly the same. By looking back at the Wild West of 1980s family law, we gain the foresight to protect our assets in 2026 and beyond. This concludes our masterclass on the 401k divorce in 1980s USA. The precedents set then are the walls of the room you are standing in today. Stay diligent, stay informed, and always check your records.